We're going to move now to our next presenter, Mr. Jonathan Alexandre, who is an attorney at law with Liberty Counsel. It's a legal organization that specializes in freedom of speech cases, and he's senior counsel for governmental affairs. And he's going to talk to us on the topic of whose choice, legal abortions and religious freedom restrictions. Mr. Alexander, thanks so much for joining us.
Thank you for having me.
And I hand over to you now. Thank you.
Thank you. So, as you mentioned, whose choice, legal abortions and religious freedom restrictions. So thank you for the invitation to address that. And thank you for the precision of the title. For while abortions are legal, they're never lawful. And it's important to set that out at the outset. The practice is never consistent with the laws of nature or nature's God, but it's been judicially imposed on nations, judicially imposed on the United States. But at the same time, it's also had cultural acquiescence to the practice, where the culture is in many ways complicit to promoting this practice. But even worse than that, it now seeks to ensnare those of religious convictions to participate in that same evil, despite that individual's or that entity's religious convictions against the practice of abortion. And we believe that religious liberty, the right to exercise worship, is a universal human right. That's the universal human right of exercise and expression. And so in the United States, it's a protected right, a right that ought to be free from government reach. That was the vision of the founders, as the founders enshrined it in the First Amendment. It's the vision of my organization, Liberty Counsel, as we carry on and take cases that hope to set a strong and lasting precedent of preserving exercise and expression. So contrast that fundamental right of exercise, of freedom of expression and religion, contrast that to the hedonistic, self-indulgent, murderous, opportunistic practice of abortion. This practice that is morally incompatible with the Judeo-Christian ethic. Yet it's filtered its way into American jurisprudence. And now it is shackling those that have abortion promotion with those of conscience and religious and moral objections, shackling them together so that anyone that has conscience and religious or moral objections are silenced and not able to speak out against it. So that's the picture I want to create. And think of it as being a far cry from any traditional American ethic. It's not a fundamental right of abortion, and any fundamental rights that are there, including the rights of religious expression and exercise, are now being shut out because of the so-called right to abortion. It's in that very juncture where many legal battles are waged. They have varying degrees of success, and they're continuing now even as we speak. And so in the next few moments, I want you to hear these three things. The stories of the individuals and the institutions that are most affected by the forced compliance to the abortion mandates, and use those as anecdotes and experiences that have happened in America that you can take back to your country and see these are the individuals and institutions and some of the stories of folks affected. Second, the legislation and the policy that feeds the abortion compliance, and even the personnel, those that are elected to office that are feeding abortion compliance, forced abortion compliance. And lastly, the laws that are on the books and the attempts to silence any speech that opposes abortion. So first, let's talk about the individuals and the institutions most affected by abortion mandates. These are the individual doctors, nurses, practitioners, medical students. These are the people that merit first discussion because they're on the front lines. They're having the work of their hands and their very labor joined to the practice that they strongly disagree with. It's often said, and should often be said, the ethic of these practitioners is to do no harm. So already you can see it's incompatible with their ethic of doing no harm and forcing them to practice abortion. The two of them will always be at odds. And that opposition is only made stronger. It's only strengthened when that individual has a specific religious and conscience or moral objection against the practice of abortion. So not only the onus to do no harm, but a specific religious conviction that they cannot join into this practice. Now, sadly, these individuals aren't given the exemptions that they properly deserve. And those that are given those exemptions are only given those exemptions when they stand up, when they raise their head above the crowd and are willing to fight for their positions. And so to that end, I think of the nurses in 2010, 8 nurses at Nassau University Medical Center. They were disciplined when they raised their objections to assisting in the performance of an abortion. It took a strong resolve from these nurses to demonstrate to the hospital that they had a conscience and a moral right not to participate in abortion. Over time, the hospital there did issue an apology, and it said it intended to reform its practice, but that only came when the nurses decided to join together and take a stand. I think also of Kathy DiCarlo. She was a nurse at Mount Sinai Hospital in New York City. In May of 2009, she was forced to participate in a late-term abortion, despite her long-standing religious objection to participating in abortions due to her Catholic belief. The hospital in that instance threatened Ms. DiCarlo with the loss of her job, the loss of her license, the loss of her livelihood if she refused to participate in the abortion. It took a lawsuit that was filed on behalf of Mrs. DiCarlo for her to pursue her rights. In March of the following year, it took an additional request to the United States Department of Health and Human Services for them to then launch an investigation to those conscience violations. All these efforts were taken so that her rights would be respected by the hospital. She had to go through many layers of authority to ensure that she would have the choice not to participate in abortion. So whose choice is it, really? It took her 3 years to resolve her case. And while the hospital eventually made changes to its policy and procedures to ensure that her and other medical personnel would not be forced to participate in abortions, it took a very long time to get there. I think of Kathy's story. I also think of Sarah Helwich. She's a young nurse, a midwife. After completing her education in midwifery, she sought employment at a Florida hospital. And during her interview, during the sit-down conversation that she had with the hiring director, she was questioned about her membership with the American Association of Pro-Life Obstetricians and Gynecologists. She was questioned during that interview about her pro-life religious objections to abortifacients and birth control. She then was informed after her questioning that because she was a member of a pro-life group and because she held on to her religious convictions, she would not be allowed to proceed in the hiring process. Her choice to believe a certain way disqualified her from employment. So whose choice is it really? Sarah, Kathy, and the 8 nurses' stories are examples of individuals who have committed their lives to helping others. They're spurred by their faith, their commitment to charity. Nevertheless, their livelihood are at stake. They're threatened because of the convictions that they hold, because of their refusal to join the work of their hands into this practice that is contrary to their religious beliefs. There are 3 different instances that have varying outcomes, but that just shows and demonstrates the ongoing difficulties that people of faith have while providing healthcare service in a country that has legalized abortion. And this is even in a case, these cases happen despite there being federal and state statutes that ought to exempt individuals from violating their conscience in this matter. Yet folks are forced to ask a high court or ask a court to be a backstop for their rights. And that's frankly a terrible place to be if your rights being expressed or your rights being protected hinge on the opinions of a judge. And I make that point to say that when the discussion comes up in Jamaica, when they say, hey, we'll institute this right to abortion, but at the same time, we'll give religious exemptions and that'll act as a safeguard. Don't fall for that. It is a practice that is not satisfactory. That is a low-level standard. It's a low bar that will easily be discarded. And these individuals and their testimony is evidence that it will only take a matter of time until that is completely ignored. And it's not just the individuals, it's institutions, hospitals themselves that face the same moral compromise in light of what the American jurisprudence did. It's very shaky in how the rights that are established in our jurisprudence are there to preserve the rights of individuals, but also the rights of hospitals and entities, different institutions, like hospitals receiving federal funds or health service programs, even private universities that are getting grants for research. All these institutions have been challenged by the requirements to participate in activities to which they have a religious and moral objection to, if they're going to receive federal funds. So it's individuals and it's entities. I think of most of the Catholic affiliated hospitals that have an ethical and religious directives that they must abide by. It's within their faith, tenets of their faith that keep them from participating in abortion or sterilization or contraception or assisted suicide. These practices are all in direct conflict with their faith. Nevertheless, there are schemes within federal funding given to hospitals that seek to attach those federal fundings to the participation and even promotion of those aforementioned life-ending procedures. And if these hospitals or these private universities are firm in pushing back against this, they face the removal of federal funding. Federal funding, if removed, will cripple their ability to perform any medical service. So once again, these entities, just like the individuals, have a choice, right? And the choice is between violating their faith and practicing abortion or continuing funding, which is no choice at all. It is not a fair choice. And of course, in the 1970s, this problem was anticipated. 1970s, the same era where there was this judicially recognized right to abortion via Roe v. Wade. And so the government said, well, we'll set up church amendments or the Coates-Snow Amendment or the Weldon Amendment. We'll set up these amendments to put in place so that entities that are providing healthcare could still object to sterilizations, that individuals could still object to performing abortions and still receive federal funding or still keep their employment. You know, these very amendments were placed into law at the same time, and they were meant to prohibit public authorities from conditioning the receipt of federal funding with the promise that these individuals receiving the federal funding would participate in abortions and force their personnel to participate in abortions as well. But despite that being the legislative intent, despite that being the statutes on the book, these legal safeguards, despite them still being there, these legal safeguards have been impotent. Many hospitals still fall prey to participating in activities they disagree with in order to retain federal funding, or individuals participating in abortions or performance of abortions just to keep their job. Even when there are laws on the books, too many hospitals are stuck with the choice of receiving federal funds and continuing to do an activity that they disagree with. And the reason hospitals are stuck in this place are for two reasons. The first is inadequate enforcement tools. So yes, this law is on the books, but there is no potency in the enforcement of the law. The church amendments or the Weldon Amendment or the Coates-Snow Amendment, they're powerless if there's no enforcement. So this is 1970 when these are put in place, but it was not until 2018, 50 years later, that the Health and Human Service Agency in the United States decided to take a look at this, to start investigating forced violations of conscience. It wasn't until the Trump administration in 2018 that the Office of Civil Rights within HHS, the Health and Human Services, decided to have a conscience and religious freedom division in an office that would particularly pay attention to violations of conscience. And sure, I suppose in the past 50 years, there would have been a spreadsheet somewhere of these violations. There would have been a catalog of complaints somewhere, but there was no active willpower to investigate. That's all just to say, even when these laws of conscience are on the books, if there is no onus to investigate, no willpower to investigate and prosecute these things, then these laws are meaningless. Second, there's a lack of awareness. Many of these hospitals and these individuals working don't even know the protections that are in federal law. And to the extent that they have an awareness, there's confusion. And even if they're clear about it, they still have to make the choice, it's not really a choice at all, between continuing in their work or acquiescing to what they're being forced to do and participate in abortions and like services. It takes a consistent drumbeat of communication and campaigning to get these entities up to speed, to know what their rights are, but also give them the incentive to say, yes, you can in fact fight and win. Think of the many entities that have already been caught up in the torrents of forced compliance without the knowledge that they can escape or without the boldness to take a stand and fight back. Couple that with the incentive to protect rights or the discretion of the prosecution. lies at whatever power is in place. So even if these individuals or these hospitals want to fight back, the discretion still lies on whatever administration is in power as to whether or not they will enforce these laws. And that changes at the whim of whoever is in the Oval Office or whatever executive administration is in power. Basically, if you have a pro-life president, the laws that are on the books meant to protect religious choice are effective. They're used in that manner. But if you have a pro-abortion president, those laws are ignored and not enforced. An example of this is just 4 months ago. 4 months ago today, the laws were enforced by Secretary Alexandre, who had a history of preserving conscience protections. But now, if confirmed, the individual at the helm of the Health and Human Services Agency is Javier Becerra. He was formerly an attorney general that my firm fought against. We faced him in court because he persecuted pro-life individuals. He persecuted Sandra Merrick, who was a grandmother that exposed the horror of Planned Parenthood to the world. Javier Becerra is the same attorney general that targeted the Little Sisters of the Poor, forcing them to violate their conscience through their entity by forcing them to provide insurance that included contraceptives. That's why there seems to be no real choice for these hospitals when they want to follow their convictions on the abortion issue. The enforcement mechanism is inadequate. The hospitals may be unaware, and even the protection that is there on the books can change based on who is in office. And lastly, there is the area of speech itself. American jurisprudence has a checkered history on how it treats individuals and entities that want to speak up against the practice of abortion. For this, I think again of our client, Sandra Merritt, who I just mentioned. She's a journalist, and her investigative journalistic work exposed what happens within an abortion facility, where doctors were caught on camera bartering the sale of baby body parts. As we defended her in court, defended her courageous willingness to speak up, we were able to place on the stand an abortionist who told the court how they would place forceps on the throat and the hips of babies. They would crush above and below the abdomen in a way to preserve the organs, as many organs as they could, in order to sell them for profit. Sandra Merritt exposes. She was using her First Amendment right of freedom of the press and speech to expose the horror that was abortion. Yet she was brought up on criminal charges. She was brought up on criminal charges initially by Kamala Harris, who was the current vice president of the United States when Kamala Harris was attorney general. The prosecution was then carried forward by Javier Becerra, the current nominee for the Health and Human Services Secretary. That's the threat that befalls individuals who seek to stand up and speak against the practice of abortion. It's not to mention the cases that have made their way all the way up to the Supreme Court, where pregnancy centers who specialize in providing alternatives to abortion were forced to speak or forced to put out publications and pamphlets to their clients that these pregnancy centers are trying to rescue. They were forced to tell them that you have the option to go next door and discard your baby. And it took a Supreme Court intervention to protect those pregnancy centers and protect those individuals from that law that forced them to promote abortion. Even still in the speech context, and we heard this before happening in the UK, but it's happened here in the United States. I think of our sidewalk counselors, these individuals whose hearts are with those that are in their very turbulent times, individuals that are about to enter abortion facilities. And these sidewalk counselors are the last voice of hope, the last voice that they will hear telling them that they can keep their baby and not destroy life, telling these expected mothers that they have the resources, the support that they need to raise a baby. Well, there are laws on the books, and we fought against them, that disallow sidewalk counselors from having conversations with these mothers, literally limiting their ability to talk to them. These are challenged. These are the challenges that the objectors to abortion face, where even what you're saying is limited. And these challenges have varying legal degrees of success, whether they're in the arena of free speech, whether it's the nurses that we've mentioned, whether it's the hospitals or the entities that are receiving federal funding, or those speaking out against abortion, the choice is not really a choice at all, but it's a choice between upholding the religious convictions that you believe that puts you at odds with the abortion laws. But the fight continues, the fight to preserve life, and we're actively seeking to preserve life, shaping the culture that promotes life, reshaping the American jurisprudence to promote life. It's a continuous battle. It's fought daily in the courts. It's fought in the legislative halls. But at the same time, and I'll just mention this quickly, it's not just the laws that are already on the books, but it's legislative fights that we're currently in. There's a proposed law that's already passed by the House of Representatives. It's waiting just outside of the Senate chamber floor. President Biden has already committed to signing this Equality Act. And it's a proposed law that names pregnancy and related services as a protected class, which means those related services ought to be provided to an individual. And by related services, they mean abortion, contraception, sterilization, other related activities. If that individual is not able to receive that service by an entity, then that entity has discriminated against them in a manner that the full force of federal government can be arrayed against this entity. And for the first time in history, there is no defense to that. Previously, the Religious Freedom Restoration Act, an act that was enacted specifically to protect an individual's conscience or religious rights, that act is cut out. It's literally gutted in the law. It's no longer used as a defense for individuals or entities that don't want to provide these abortion or pregnancy-related services. So this law passes, it is truly the death knell when it comes to conscience or any moral or religious protections. It is such a broad law. It applies to every entity, and not just the hospitals that I mentioned before, the ones that are directly receiving federal funding, but it applies to anything under public accommodations, which means any private hospital, any medical provider, anyone that is providing a service or a good. It's intended to do so to provide sweeping federal law enforcement against anyone who's hanging a shingle out as a healthcare provider, even if they do not want to provide abortion, sterilization, and other related activities. So my friends, to say that the legal and policy work is cut out for us and cut out for your respective countries is an understatement. But it's precisely where we ought to continue to take a stand. These laws and legislation are a reflection of our culture. So I think that's where the work needs to be done first. With talks like this, with people around your dinner table in your home, tell them of the atrocities and horrors of abortion. Commit that every time your voice is heard, that the people listening to you in that setting hear of your commitment to life and are inspired to do the same, to commit to life. And every time that choice is placed in front of you personally to hold on to your religious and moral convictions in the face of a government or a culture arrayed against you, that you have the boldness and the conviction to take a stand, knowing that you have the full weight of justice and truth on your side, despite the present difficulties, knowing that your fight is not in vain, knowing that you're fighting for a fundamental right of believing in the first universal human right, the right to life, but knowing as well that your devotion to God and the exercise and expression of your faith should not be trampled on by your government, regardless of who the government is. So my fellow panelists, the organization, and those listening, take heart. Know that the work that you're doing is important. You play a vital role in setting out the culture and the law and policy that has an impact today, will have an impact on generations, to those who will experience the joys of life because of your hard work. So don't be weary in doing good. Be aware, know the terrain that you're fighting on, but continue to take the stand for the sanctity and preservation of life.
Thank you very much, Mr. Alexandre, and for sharing some of those cases of those healthcare workers who are seeking to live by their religious convictions, but also the commitment that they made to the Hippocratic Oath, first do no harm. And what you've shared and what Dr. Oas has shared, and also from Ms. Williams, is really quite evident that the pro-abortion campaign are taking away our choice, the choice of the baby, of the mother, of the healthcare providers, of nations, and are imposing their choice on us to force us to legalize abortion. And they're just sweeping away, stifling, suppressing communication of the truth of what this horrific act is. And we must call it for what it is, Mr. Alexander, as you have. It is murder. We must call it for what it is and not allow it to be hidden under the euphemism of sexual reproductive health and rights or termination of pregnancy, as we hear very often in the Jamaican space, without saying exactly what kind of termination we're talking about. I know you have pregnancy and related services, so we must know what the words mean and call it for what it is exactly.